All right, let's continue this discussion now. Still on the CJN controversy. I am now being joined on the program by Professor Ishe Sagay, who is, of course, the presidential advisor on that's the presidential panel on anti-corruption, and he's also a professor of law and a senior advocate of Nigeria. Prof, thank you very much for joining us on the program. This must be a very sad development for you, Prof. You're a senior lawyer. You've been teaching law for a very long time. I'm sure this is something you have not seen before.
No, absolutely not. Absolutely not. I've studied the judiciary and their achievements in Nigeria quite thoroughly. And this was not at all within the compass of what I've ever come across.
And for you, how should this issue be dealt with? Because there's this raging debate over whether this case should be tried, should go to the NJC, or it should go to the Code of Conduct Tribunal.
Well, all the arguments have been made. In this country, unfortunately, because of the elites who thrive on a distorted, convoluted system by which they make all the resources at the expense of the masses, truth is always the first casualty. Everybody knows the Constitution has provided very clearly that any public officer charged with anything to do with declaration of assets compulsorily has to go to the Code of Conduct Tribunal. Only and only the Code of Conduct Tribunal. That's the Constitution I'm talking about. Even the judgment they are talking about,
yes,
they've been quoting in the Giwa itself, much as I think that judgment is invalid, but even that judgment was able to realize and state that it applies only, the principle there applies only to cases in which the judge is acting as a judicial officer in his own court. That if he is caught up in anything outside his court, like murder, theft, accident, dangerous driving, all those things, it will go to the normal courts and not to the NJC. And if I may add, there was a case in 2013 at the Supreme Court, presided over by Ononge, CJN. I don't know whether, no, it wasn't CJN then, but presided over by Justice Ononge, in which they declared themselves that the Code of Conduct Tribunal only can hear any matter arising out of declaration of assets, that no other court, that all other courts are excluded completely. He presided over that court. So my 2 points I want to make here. One, why are the senior advocates being so dishonest and fraudulent just because they want to protect their pockets? That's the first point. Secondly, Chief Justice of Nigeria, head of an arm of government that I think probably the most important arm.
Yes.
Because they are the one who sit in judgment over the other two. And whatever they say is final. Why should a person who heads such a very highly important post, which I always say is really next to God in rank, why should he sit tight when a thing like that is revealed? He has admitted, in fact, if he didn't actually do anything so specifically but conducted himself so as to arouse suspicion, he should step aside because of the institution he heads. In this case, he has admitted that he did it. He should have left honorably.
But he said he forgot.
Yes. That is an offense. You shouldn't forget. You shouldn't forget. If you do, it has the same impact. That is, the state not knowing what assets you have, so that if you now acquire assets in a corrupt manner whilst in office, nobody will know the difference. So this is the thing. Once he found out the situation, he would have said, yes, I made a mistake, I forgot, I am sorry, Nigerians, I'm not going to contest this thing, I resign, as a standard for those who are going to come after me. So in all this now, all the things happening now, you find all these so-called senior advocates, who in my view are just parasites, hiding the truth under the table, looking for injunction, applying for interlocutory application, talking about jurisdiction. They are dancing around everything on earth except the substance. Who did it? Did he do it? That's what they're avoiding. They don't want it ever to come to a stage where a court has to decide, did he do it? And any system based on that, and any group of people who live in that type of dishonest atmosphere and environment are a danger to our democracy and to the rule of law. Now, Prof, those senior advocates are a danger to our democracy and to our rule of law.
There's something else I want to ask you, Prof. Now we've seen two courts. A federal high court issue a restraining order. Then you have the National Industrial Court as well issuing a restraining order. Would these orders now be binding on the Code of Conduct Tribunal?
Yeah, well, the orders, the effect of the orders is that whatever is filed before them will have to be decided before the Code of Conduct Tribunal can validly continue its activity. That is the implication. Although I myself have not done any study of it, of whether they stand superior to the Code of Conduct Tribunal to be able to issue such orders. I have not done that study, but that's the implication. That's the implication. And let me just finish that. You see, the practical consequence of that is that the case will never come to an end, because they will decide, government will appeal, it will be a decision in the Court of Appeal, who loses will appeal to the Supreme Court.
But if that happens, we can't deny the fact that it's the image of the judiciary that will be further dented, because whether we like it or not, the image of the judiciary is already dented as we speak, and the image of the Chief Justice of the country, whether or not he likes it, is already dented by this development.
That's what I'm saying. The whole institution is negatively impacted by, not by what happened, but by the lack of grace in not simply admitting and stepping aside, instead of fighting the charges, going to try and stop it from being heard. If, in fact, he had even said, okay, I don't accept the charge, I am innocent, let's hear the case, that would have still been acceptable. I think resignation or retirement would have been best, but that's the second best. But to now create a situation where the case will never be heard is a great disservice to our judiciary, it's a setback to democracy and the rule of law.
But if this case goes to the NJC, do you have any confidence at all that justice could be served?
NJC is CJN. You can see that even their initials are the same. The CJN is the owner of NJC. He's not just the chairman. He picks 20 out of the 23 members. He owns it. So sending anything to the NJC is like sending something to a person for him to be a judge in his own matter, which is absolutely contrary to our, which is absolutely against our Constitution. It's a breach of our Constitution and a breach of common law, even if there were no Constitution. This situation has existed since 1215. when King John of England had to issue that Magna Carta at Runnymede in England. That has been the situation. So we just included it in our constitution because we are the successors, in effect, of the British authority in Nigeria.
What if the CJN recalls himself?
Does it make a difference? His appointees will be there. They meet at regular intervals. They decide things together. They drink tea together. They have conclaves and all sorts of consultations together. They're always together. They are friends. They are close. So there's nothing is going to happen. Remember what happened to Justice Salami because of that, when he had a disagreement with the CJN. So let's just forget about it. It's laughable. No serious person will say this matter should be taken to the NJC. No serious person. Anybody saying that is trying to ridicule this country.
But how damaging do you think this is for the Nigerian judiciary?
I think it's extremely damaging because we want to have confidence in the people there. We want to believe that they are above board, that like Julius Caesar's wife, they are above suspicion. Nobody holding a high position of that sort should carry on with that type of baggage, no matter the person's power. Survival and remaining in office, in my view, even for such a person, is a form of tragedy.
All right, Professor Sagay, thank you very much for joining us on the program.
You are welcome.
We'll take a short break and I'll be coming back to close this program. Stay with us. On Deji360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent. Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country?
I wish we had people like Tony at the National Assembly.
God forbid that I go to join that band.
Deji360, providing clarity to issues.